speaking. With me, Tarun Nangia. Today, we're going to discuss an issue which is very important to the investing community in the country, mainly the promoters who are looking to invest long-term in India. That is whether the challenge to the arbitral awards can be directly taken at the High Court level. And why is this important? Because for any investor, certainty of dispute resolution is of utmost importance. And whenever we have discussed this with promoters, they say that arbitration was introduced as a medium of faster dispute resolution. And when you have to again start from the district court level, it only increases the time, and thereafter the industry's capital gets stuck. So today we've got three eminent panelists to discuss this issue on whether now the arbitral award should be challenged directly at the High Court level. May I introduce to you Senior Advocate Ratan Singh. He's well-known arbitrator, especially in the construction sector, practices at the Delhi High Court and the Supreme Court of India. He's also an international member of Keating Chambers, which is one of the world's best known construction law chambers based out of United Kingdom. He's also the director of Chartered Institute of Arbitrators, United Kingdom's India chapter, as also chairman and founder of the India chapter of Society of Construction Law. Welcome, Mr. Ratan K. Singh, and requesting for some very interesting inputs from you today. I have with me Justice Sheshadri Naidu. He has served as a High Court judge at the Andhra Pradesh High Court, the Bombay High Court, and the Kerala High Court, and now practices as an arbitrator and an advocate counsel at the Supreme Court of India. Welcome, Justice Naidu. And since this is your first appearance on Legally Speaking, looking forward to some very interesting inputs from you. May I also welcome Abhishek Saroop, partner with Saraf and Partners, and which is one of India's leading law firms. Abhishek, good to see you again, and looking forward to some interesting inputs from your end. At the outset, may I request Mr. Ratan K. Singh, Senior Advocate, that in about next 3 minutes, if you could lay the ground for today's show, and then we can move forward to the opening comments.
Thank you, Tarun, for putting together such an interesting and eminent panel. You talked about very interesting aspect about arbitration, that all stakeholders, the disputants who are the parties to arbitration, really look at faster settlement of their disputes. And one of the reasons why they go to arbitration is faster disposal of disputes. We have had legislative changes in Arbitration and Conciliation Act, as a result of which now we see faster disposal, because now it is 6 months plus 12 months within which arbitral tribunals have to give their award. But when we get the award, what happens thereafter is an area of concern for all of us, all stakeholders. And question is whether the challenges should be brought before high courts directly, or it should go to district courts or the district courts in various states. Obviously, Delhi, Mumbai, Calcutta, Madras, you go to all these high courts have got original jurisdiction. So you go directly to high courts beyond a particular pecuniary limit. But you in other states, other places, you have to go to district courts. Now, question is, what is that which troubles the award holders or all the stakeholders, so to say? The way annulment proceedings or the challenges to awards are dealt by those courts. See, I'll give you a contrast. In Delhi High Court or in other high courts where high courts have got original civil jurisdiction, substantial number of challenge proceedings, annulment proceedings are decided and dismissed on the very first day. If court finds there is no merit in those challenges, they dismiss it straight away. But when we go to district courts, difficulty is district courts treat them as one of the regular proceedings, normal, original side proceedings like a suit. So in routine manner, without asking the challenging party to disclose why courts will entertain their petition, courts will issue notice so that the attendance and appearance of the other side takes a lot of time. They will try to avoid, awardators will try to avoid as much as they can. Then they may have to go for publication. as and when they appear, then they'll start taking time for filing of replies. Then again, it goes on and on and on. So it basically delays the whole process, and it really goes in the teeth of the provision which was brought by way of amendment, that we should dispose of these proceedings at the earliest. That is not happening in those district courts. That is the first thing which immediately comes to my mind. There are ways how we can tackle these issues, but my first reaction is that district courts, an answer to this is very simple. If Supreme Court passes one judicial order, passes one direction on judicial side, that all courts should first see whether the petitioner of those challenge proceedings are having good case to sustain their Section 34 or challenge proceedings or not. And only after having satisfied themselves that yes, they have really made out some good case for challenge, only then courts should issue notice. If you have one such direction coming from Supreme Court, it will take care of lots of issues.
So you've raised a demand in today's introductory comment that there should be a direction from the Supreme Court. We will see if that happens. I'll go to Abhishek Swarup for his opening comment on this issue. You heard Senior Advocate Ratan Singh. First of all, I would also like to ask whether you agree with his demand of a direction from the Supreme Court, and then your opening comment.
With due regards to submission made by Mr. Ratan Singh, I just had a small deference to that. The thing is, we need to take a picture of the present legislative scheme which is there before us. Now, in the present scheme of things, the Arbitration Act is also to be read along and seen along with the Commercial Courts Act. In these four jurisdictions, which we have earlier discussed also, Delhi, Bombay, Madras, and Calcutta, which have original jurisdictions, the Commercial Appellate Division, which is the court which deals with the appeals, or Section 34, as we call it in common parlance, which challenge under which the challenges lie, go before the High Court. Now, if that very legislative amendment, very legislative scheme is only sought to extend to all 34 challenges, rather than an observation of a Supreme Court, the existing scheme itself takes care of everything else. So that is one way to handle this situation. There are Commercial Appellate Division existing in the court, a legislative scheme is there. The only thing is, if it extends to all Section 34s, all challenges of arbitral awards goes before Commercial Appellate Division of the High Court, and the issue takes care of its own. That is what is my suggestion in response to what Mr. Ratan Singh said. Coming on to the next point, why is this needed? The need is perpetuated or accentuated by the fact that today most of these disputes are arising out of complex commercial transactions. More often than not, parties do go appoint the either retired High Court judges, retired Supreme Court judges, or even in some case these specialized arbitral arbitral institutions. An award from that forum, if the party who has lost it is the first attempt is to somehow derail the process of their enforcement. And the obvious thing is, file the challenge in a very remote location, in a remote district where neither the infrastructure is there, neither the judges who are sitting in that jurisdiction are competent, not to demean any of the judges, but are competent. That's why this suggestion, which the topic which you have put in today's forum acquires very, very importance in today's scenario. That's the opening comment I would like to make.
Thank you, Abhishek, for the opening comment. I'll go to Justice Naidu at this point. So you've heard both the panelists, Senior Advocate Ratan Singh and Abhishek Swarup, partner of Saraf and Partners. Now you have this unique position where you come from of having been serving as a judge in the High Courts of Andhra Pradesh, Bombay High Court and Kerala. Could you share your experience in this aspect of arbitration with us and your opening comment?
Thank you very much. Well, when it comes to Indian adjudicatory system, the whole thing boils down to one thing, the delay. And the delays indeed are enormous. Even our topic today's focus is on that one. Should we remove 1 tier of adjudication instead of having your section 34 proceedings before the district court, have it before the high court, and then move on to the Supreme Court? And the learned senior counsel, Sri Ratan K. Singh, has set one pertinent issue that it's time the Supreme Court issued a directive so that could bind all courts and tribunals, and that will have something which could avoid the confusion. But the problem is this. See, for example, an American Supreme Court, it sits en banc. All 9 judges sit together. They decide. You can as well visualize one voice consistently all through. Whereas in India, the Supreme Court sits in panels. It is not one Supreme Court, legally speaking, though we refer to in the singular, it's say about 16 Supreme Courts. And the consistency is a very difficult thing because the precedent, whatever value it has, despite Article 142 and 141, it's fact-bound based on that. And in fact, if you think of any universal direction that applies on all occasions, you take an example of Article 226. Time and again, the Supreme Court has been defining and redefining and re-articulating what could be the scope under that one, the sort of self-imposed limitation. But still, it defies any categorization. So this is perhaps the uncertainty we suffer from. What I would like to look at is the problem with Indian judiciary is institutional, inadequacy of infrastructure and manpower. And we have been indulging in labeling. What happens? You take the example of, say, for example, family disputes. Family court, a special court. And the procedure is completely summary. But that family court now has been burdened with every other jurisdiction. Now you take commercial courts. The same thing has been happening. We have got the wonderful laws, but when it comes to implementation, we don't have that expansive infrastructure. The same judge will be labeled as this, that, and it goes on endlessly. That's why, unless we address this basic issue, this superficial labeling and relabeling will not solve the problem. I reckon that way.
Okay, thank you for that opening comment. Now we throw open the floor. Before asking the next question, I'll go to Senior Advocate Ratan K. Singh for his response to your comment, and then we go on to the next question.
It was really interesting to hear Justice Naidu. In fact, I had shared same thought in Harvard University in 2014 when I was invited to speak in Harvard India Conference in Boston. And I had said, hey, we do not have one Supreme Court, unlike you. See, I'll tell you what is global practice when it comes to challenges brought to courts. UK, you have commercial court where all the challenges to domestic awards are brought, and which is part of the High Court. In Singapore, again, it is General Division of High Court, which looks after all these setting aside of arbitral awards. France, you have Court of Appeal. Hong Kong is an interesting jurisdiction. There again, you have Court of First Instance of High Court of Hong Kong, which is a competent court for setting aside of arbitral awards. An interesting thing about Hong Kong is that Court of First Instance in Hong Kong has a specialist arbitration list containing judges with experience in arbitration-related matters. If you have a problem with burdening high courts with all the challenges, the arbitral challenges proceedings, you want to avoid that. To start with, at least what we can suggest is, and what can be done is, even in district courts, why cannot you train some of the judges and prepare a list of those experienced judges having exposure of arbitration-related matters? See, there are two aspects, Tarun, we should keep in mind. One is that we should fast-track the process, because this is what one of the guiding factor is behind the arbitration as a dispute resolution mechanism. But at the same time, we should also think about, and we cannot lose sight of the fact that we need a good quality decision. See, understand one thing. Most of the awards in India are passed by retired Supreme Court and High Court judges.
Yes, yes.
And you are taking those awards to district courts, which is being reviewed by the district courts. So least we can do is train our district court judges for commercial matters, particularly for arbitration matters. I'm not saying anything against anybody or for that matter who are judiciary. I'm not talking about that. See, I'll tell you, even the Arbitration and Conciliation Act has made certain provisions for international commercial arbitrations, like challenges to international commercial arbitrations will go to High Court. Appointment of arbitrators for international commercial arbitrations go directly, the proceeding, one has to go directly to Supreme Court. So there is something behind this. Why this distinction? Distinction obviously for the region that you need more experienced judges. Now, question is, either you go straight away to High Court, take up all these matters straight away to High Court. If you cannot do it, to start with, at least let us have a more specialized judges in district courts. We should train them. And as I said, see, I agree with Abhishek that we have the Commercial Courts Act, Commercial Court Appellate Division Act. All of this is there. You have even for many situations in the Arbitration and Conciliation Act, you have given timelines are also given. But as Mr. Naidu was talking about how to go about it, if you have one order, judicial order passed, like it was done in the case of election petitions. In fact, I had argued that matter in Supreme Court. And Supreme Court said, decide all election petitions within 6 months. And now in all high courts, election divisions were, election benches were constituted. So once you have some direction from Supreme Court, obviously Supreme Court cannot direct about having list of specialized judges, but at least to curtail those unnecessary procedural things which is not needed at all, which I said in my first opening remarks. Before
I go to Abhishek Swarup, one 30-second comment from you, Senior Advocate Ratan Singh. Now you deal with these multiple 1,000 crore or multiple 100 crore construction disputes. Most of these disputes are happening when these companies have taken bank loans and they are servicing the debt. And when this delay happens, what kind of the pressure the client or the company goes in? Can you share in 30 seconds and why this is important?
See, this is you have really raised a very pertinent thing on the construction arbitration side. The stakes are quite high, quite substantial. And every days of delay really is like killing those award holders. And difficulty is, howsoever delay you may have in all the disposal of all the Section 34 challenge proceedings, the parties are not compensated the way they should be for the loss they suffer because of all these delays. Their capital remains stuck. They are incurring huge cost in defending the award. So that is another area where we should really look at, where the parties who are stuck with the award in their hands and the challenge proceedings are taking months and years together, they should be really compensated with actual cost and actual loss which they suffer.
That's a fair point. In fact, I remember an earlier show that we did with Mohit Saraf, managing partner of Saraf and Partners. And he said that if our system was working well, why so many infrastructure companies are going bankrupt? If the system is working well, then infrastructure companies should have done very well. But we see most of them going bankrupt. I'll go to Abhishek Swarup for his comment. I would also request you to reply to Justice Naidu and what Senior Advocate Ratan Singh said.
Thanks, Tarun. So I would again come back to my original point, and what Justice Naidu as well as my senior colleague Mr. Ratan Singh said is we are heading in the same direction. Is that there are two ways this impasse could be resolved. Is either we train and make the district court judges competent.
Yes.
Right? Or we move this system, as you're suggesting, as per the title of the court itself, to the High Court.
High Court.
Right. So those are the two-way options. Now, the first option, where we talk of training and making the district court judges, I agree with what Justice Naidu said. I'll give you an example. In fact, just a couple of weeks ago, I was doing a Section 9 matter before a district judge in NCR only, not the Delhi courts, but an outskirt, which is Gautam Budh Nagar. The impression of the judge was that this person knows arbitration better than many of the lawyers appearing before him. And as the matter progressed, and as we were explaining him, unfolding him, the questions which were forthcoming from the bench, from the judge, were actually reflective of the same. That's the kind of judges, and that's the kind of trained judges or trained minds, if we have, it will actually solve the problem. Nothing needs to move anywhere. That is what Justice Naidu pointed out. But the problem is, that kind of judges are in a district court are very rare to be found. That judge was a former advocate on record, practiced at Supreme Court, then joined the district judiciary. So that will take some time for that judges to come in, that kind of judges to come in, because it entails a lot of other things, the infrastructure, the pay package and everything. While the promoters, the companies are looking for a near real-time solution, how do you get that? And that is where we come in, that we will have to, maybe even though we take away one line of challenge from the district court and bring it up to the High Court, but comparative to a district court, high courts are much more better aligned in terms of handling these commercial disputes, understanding the complex nature, understanding the stakes involved also. So due regards is paid to the stakes involved in the context in which the matters are sought. So that is how a solution could be arrived at. There is one more point, again coming on to the point which Justice Naidu said, and this point I had raised in an earlier issue also, that even in High Court, this may not actually serve the purpose, because we have judges who are not trained particularly on the arbitration. And by change in roster, they are just put into the commercial division where they have to don that hat. That was the terminology I used also. That won't work. We need to have judges who are oriented and aligned with the progress in the arbitration field. That is how we will be able to progress and get this delay issue resolved out of our arbitration mechanism system.
I'll go to Justice Naidu here, sir. One interesting input. I was discussing with Senior Advocate Ratan Singh. There was some 600 crore arbitration dispute. And he was telling the other time that this loan has to be repaid because this 600 crore is a bank loan. And if a high court judge retired has given an arbitral award and it now goes to the district court, imagine the frustration of the promoter that A, he is not able to pay salaries, B, he is not able to service his bank loan, and C, his company is collapsing. Do you think that we are in a kind of a tornado which is difficult to get out of? And also his point where he pointed out that arbitral awards by retired Supreme Court judges and High Court judges have to go to district courts. Your inputs on that?
Yes, that's quite an interesting aspect. It reminds me that when Ambedkar introduced the Constitution, he has said that we are basically feudal. We have superimposed democracy onto it. And he wondered how long it's going to survive. Luckily, it survived and still survives. Let's stop in the positive sense, referring as if they were inferior, the district judges. I reckon, see the majesty of the law, a decision rendered by a former CJI perhaps, in an arbitration could be tested by a district court or the district judge.
Yes.
And I tell you, there can be administrative hierarchy, but there can be never an adjudicatory hierarchy. An order rendered by the lowest court, unless it's tested at the higher echelons, is as good as the one passed by the highest court.
Okay.
This is the basic thing. And in its wisdom, the legislature has felt that the trial court or the district judge is much more well equipped because it replaces the suit culture. When it comes to an arbitration, it's a masqueraded suit in a short span of time to be decided. And the legislature has felt that they are better equipped. And what I feel is we do have very competent district judges. But the thing is, they need to be oriented because, it's something like a cricketer playing a 5-day match, all of a sudden shifting onto the T20. He is bound to falter. See, in a day, he'd be dealing with cases on title dispute, dealing with sessions cases, dealing with arbitration. Then he has to shift over when it comes to his mindset that he's dealing with something with a very, very narrow scope of interference.
Yes.
So, unfortunately, though every high court, every state has judicial academy, now they're being camouflaged as law colleges. And it's time we woke up from our slumber. And we trained these judges on the soft skills of adjudication and the entire scope of the statutory limitations they have when it comes to adjudication. And our enormous love for procedural niceties, that's sounding the death knell for any procedure. You take any law that's come out with a view that things should happen on a faster lane, but you bring in CPC one way or another and kill it off. So it's a matter of your orientation, your outlook that matters. This is one thing. And then the other very pertinent aspect raised by the senior counsel, Ratan Singh, is this. When it comes to adjudication in India, especially commercial disputes, the compensatory part is woefully lacking. Here, it pays to litigate. Whether you have a point or not, whether you have strength in your case or not, you throw some paper into the court, litigate, drag on the proceedings for decades on end, and in the end, you're not put to any sort of loss. And the one who wins it, he has only a Pyrrhic victory, only a victory in technical terms with nothing more to gain. That's why when it comes to any litigation, the loser should pay very heavily so that there could be some deterrence in perpetuating litigation. I think these are the two aspects. One thing is that competent enough for our district judges, but they ought to be reoriented. And there should be specialized judges who should not be burdened with all other sorts of litigation.
That's a good point. Specialized judges not burdened with other matters.
Yes.
So, Senior Advocate Ratan Singh, I want to come from this end. The government says, give us faster dispute resolution. You can't be a $5 trillion or a $10 trillion economy when promoters are scared to invest. That's why capital may get stuck. Do you think that if we want to grow out of the current growth rate and grow much more, we need this riddle to be solved?
See, Tarun, arbitration is a preferred mode for commercial decisions. And you talk about construction arbitration. I have said it earlier on your show that it is a different breed of animal.
Yes.
And for construction arbitration, we need construction lawyers. We need construction judges having a specialized knowledge about this field of law, who are exposed to the nuances of construction law, which we do not teach in our law schools and engineering colleges. See, difficulty with the awards is, and why this demand or wish list of all the award holders that let the challenges straight away go to High Court is, see, I'll tell you, the Arbitration and Conciliation Act, your Section 34, which is modeled on Article 34 of Arbitral Model Law. The challenges to awards cannot happen on merits. Right? It is on very, very limited grounds, as Justice Naidu said, very narrow grounds. You have very limited grounds. In fact, you can see the anguish of Honorable Supreme Court in the DMRC matter. Yes. When this Honorable Supreme Court Justice Nangia authored that speech in the judgment, where Honorable Judge had to say that because of unawareness about the arbitration process as arbitration process, while interpreting patent illegality, courts are going into merits of the matters. Courts are reappreciating all facts, all laws, and returning their own findings. That is not what is envisaged. And that is, see, arbitration is called one-stop shop. Arbitrators are masters of fact, masters of law. Whatever they decide on facts, on law, that's it. Only when award is obtained by fraud, or it is against some bigger, larger public policy issue, or it is a violation of due process where one party has not been given any opportunity, on those limited grounds, award can be challenged all across the globe. We all are model law jurisdiction. So therefore, I am saying, and I agree with Abhishek, I agree with Justice Naidu as well on this. End of the day, whether we are before high courts or we are before the district courts, we need judges who are having good experience, or who are aware of the nuances of the subject. And this is what we should look at, whether we do it, how we do it. There are many ways of doing it. We are working on this and things are improving.
Okay. Thanks so much. With this, we draw part 1 of our series where we spoke about challenge to arbitral award. Should it directly go to the High Court? All comments from all panelists indeed were very thought-provoking. We all hope earnestly that it is, a serious thought is given by the watchers of the show to this issue, because this involves all of us, the industry of India, and the growth that the political class is now envisaging. The administrators can only be possible with faster dispute resolution. We have put forth some points today on the show via Senior Advocate Ratan Singh, Justice Naidu, and Abhishek Swaroop, partner Saraf and partners. And of course, we will take on this issue again in next month. But that's it for now. Thank you so much for joining, and thank you so much, viewers, for joining us. Thank you so very much.
Thank you very much, Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.